Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. If you have been following the Idaho versus Kohberger case for any amount of time, then it's likely that you are aware that the decision to demolish the house that once stood at 1122 King Road was a very controversial matter. There were many people who expressed their concerns that the house should have remained standing, at least through trial, to provide the jury with an opportunity, if it wished, to see the actual home. There has been a ruling on one of the motions in Limine that has, I believe, possibly added, in my opinion, further fuel to the fire to those who felt that that house should not have been raised as it was in December of 2023. The motion in Limine written order that I'm referencing is state's motion in Limine regarding admissibility of demonstrative evidence. It is located beginning on page 10 of the 17-page written order that was rendered by Judge Stephen J. Hippler on April 18th, 2025, to document various verbal rulings and findings that the court made at the marathon April 9th, 2025. Motions in Limine, oral argument. The state's motion in Limine at issue here is regarding the admissibility of demonstrative evidence, and it essentially focused on the fact that the state wanted to introduce at the future trial of this matter a 3D model, not to scale, a model of the 1122 King Road residence as a demonstrative tool at trial, contingent upon the state's laying sufficient foundation to establish the basic accuracy of the model and a demonstration that it will be helpful to explaining the testimony of the presenting witnesses. Now, the defense objected on various grounds that the model cannot reasonably be evaluated by its expert in time, and this was in time of the in limine's hearing, which again, as I've stated before, happened on April 9th, 2 days before defense witness Matthew Modell presented a declaration that he would not be able to see this model in time for the hearings. What the court ordered is that while he may not have been able to see the model in time for the motions in limine hearing, there was sufficient time in the court's opinion that he could do so prior to trial. And what the court ultimately ruled was that the state was to turn over the finished of this model on or before the time of the final pretrial conference, which is set to occur May 15th, 2025. But what is most compelling about this finding, that I believe that perhaps the house should not have been raised, perhaps it should have been kept standing through trial because of what's stated in this order and the court's findings here. Go to page 10, paragraph 2. The court makes certain specific findings about this house. Says here the homicides occurred in 2 bedrooms within a 3-story home with a complicated layout, and the suspect's ability to enter the home, carrying out the stabbings, and exit the home consistent with DM's observation will be a central point of the trial, particularly given that the defendant is challenging whether it could be accomplished by one person within the time frame alleged. The model will aid the testimony of lay witnesses and experts alike in explaining the location of the victims, the witnesses, and other items of evidence, as well as understanding the suspect's potential or likely path of travel. So now this is going directly to the fact that the trial court himself, Judge Hippler, has said that it will be a key issue at trial whether or not these crimes could have occurred within what has been debated as a too short of a time frame to carry out the 5 first-degree felonies that Mr. Kohberger is charged with. The first is the burglary count, and then the 4 unalivings. Could that have been done within a matter of minutes? And will it be possible to argue pro or against this fact at trial with a demonstrative, not to scale tool, rather than the jury going to the property itself and seeing what the layout was, the entrance, possibly the exit, the 2 bedrooms on the 2 different floors, where DM stood when she says that she saw the person clad in black who was believed to be the suspect, and so many other relevant matters. Although the scale of the house was not included as an attachment to this order, it is included in an exhibit to the state's motion in Limine. And the question here that's posed is, will the fact that the house is no longer standing and it's not possible for the jury to see for themselves all of the spaces that are relevant here, and will have to be confined to looking at this demonstrative tool, assuming that the state is able to lay the foundation for its admission into evidence, is that the same as going inside the house itself, as other juries have done, including in the Parkland case? The jury toured that school building where the crimes occurred. Will the fact that this is no longer possible benefit one side or the other? Will it not, in your opinion? If it will benefit one side and hurt the other, whose side could potentially be benefited? Whose side could potentially be harmed? If you have any questions, any comments, please leave them here. As always, all of your comments and opinions are appreciated. And this is Kathy. I want to thank you for joining us here today.